Oh, if I am going to make all the hillbillies and all the rednecks happy, then I might as well do hillbilly stuff. It's me, it's my hot dog onesie, and I'm bringing you the case of is moonshining at home legal again? Oh, oof. Welcome to the show. Yeah, you might have seen the news already. Let's bring that up first. There it is. Federal judge finds Americans has constitutional right to distill moonshine in their bathtub. Well, maybe not exactly, but let's get through a bit of it. A federal judge rejected more than a century-old ban on home distilling as unconstitutional on Wednesday. Judge Mark Pittman found that a federal law making it a felony to distill spirits at home exceeded Congress' power, holding that neither Congress' tax power nor its ability to regulate interstate commerce justified the ban. Pittman permanently blocked the government from enforcing the ban, which threatens violators with up to $10,000 in fine or 5 years in prison against the plaintiffs if found to have standing. Quote, indeed, the Constitution is written to prevent societal amnesia of the defined limits it places on this government of and by the people, Pittman wrote. This is where the judiciary must declare when its co-equal branches overstep their constitutional authority. Congress has done so here. Now, let's go to the actual decision here. Here it is. United States District Court for the Northern District of Texas, Fort Worth Division, Hobby Distillers Association et al. Plaintiffs virtual ATTTBET, those guys. The government. Opinion and order. Hold on. Before the court is plaintiff's motion for a preliminary and permanent injunction, which the court has advanced to the case merits as authorized by Federal Rule of Civil Procedure 65. For the reasons distilled below, the court dismisses 3 of the individual plaintiffs for lack of standing, but grants the motion as to the remaining plaintiffs, awarding them declaratory relief and a permanent injunction. But the court stays the ability of this order for 14 days to allow the government to seek emergency appellate relief if it chooses to do so. So this means not in the clear just yet. The government can file emergency appellate relief within 14 days of this decision, which was, the date is, let's see here, 10th. So before the 24th. This is a long one. Let's go through bits and pieces of it at least. Background. The case arises from two federal statutes that regulate the location of distilled spirits plants or stills, which are used to distill beverage alcohol or spirits. Individual plaintiffs are 4 people from various states who wish to distill spirits at home for personal consumption. That's a key word here, personal consumption. Association plaintiff, the Hobby Distillers Association, is a Texas-based organization that advocates for the legalization of home distilling beverage alcohol for personal consumption. The association has approximately 1,300 members nationwide, including all 4 individual plaintiffs. And it was organized to advocate for the legalization of home distilling, which providing information and education to its member on the nuances of distilling various spirits. This is a 1868 provision. No distilled spirits plants for the production of distilled spirits shall be located in any dwelling house, in any shed, yard, or enclosure connected with any dwelling house, or on board any vessel or boat, or on premises where beer or wine is made or produced, or liquors of any description or retail, or on premises where any other business is carried on except when authorized under subsection B. And 5601 and 5178 makes it a felony, providing that any person who uses or possesses with intent to use any steel boiler or other utensil for the purpose of producing distilled spirits, or aids or assists therein, or causes or procures the same to be done in any location prescribed, blah, 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 shall be fined not more than $10,000 or imprisoned not more than 5 years, or both, for each such offense. Plaintiffs sued, alleging these provisions are unconstitutional because they exceed Congress' enumerated powers. Plaintiffs seek declaratory relief and a permanent injunction to prevent their enforcement against them. The court held a preliminary injunction hearing on March 28, 2024, and took the parties' contentions under advisement. Receiving no objection from either party, the court advanced plaintiffs' request for injunctive relief to the merits. See federal blah, 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 blah. Before or after the beginning of the hearing on a motion for a preliminary injunction, the court may advance the trial on the merits and consolidate it with the hearing. Accordingly, the court now considers the entire record on the merits, treating the parties' filings as summary judgments briefs. Legal standard, summary judgment, blah, 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 blah. Yeah, analysis, standing. The government first contends that neither individual plaintiffs nor association plaintiffs have standing to sue, primarily because they have not suffered any legal injury. Article 3 standing is a bedrock constitutional requirement that courts have applied to all manner of important disputes, US v. Texas. This is because Article 3 confines federal courts' jurisdiction to cases and controversies. Article 3, paragraph 2, blah, blah, blah. Federal courts are not public forums for citizens to press general complaints about government. Allen v. Wright. So cases or controversies only exist when a plaintiff has standing to sue. Thus, every court must ask its plaintiff, what's it to you? Ascalia, the doctrine of standing as an essential element of the separation of powers, 1983. The correct answer requires three things. First, there must be a concrete injury in fact that is not conjecture or hypothetical. Second, there must be a causation, a fairly traceable connection between a plaintiff's injury and the complaint of conduct of the defendant. And third, there must be redressability, a likelihood that the requested relief will really cure that injury. A. Individual plaintiff standing. An allegation of future injury may suffice for Article 3 standing if the threatened injury is certainly impending or imminent, or if there is a substantial risk that the harm will occur. Alleging that a future injury is merely possible is not enough, because imminence cannot be stretched beyond its purpose to ensure that the alleged injury is not too speculative for Article 3. Hence, a plaintiff bringing a pre-enforcement challenge to a criminal statute must demonstrate a realistic danger of sustaining a direct injury from its enforcement. But plaintiffs who intend to engage in proscribed conduct allegedly protected by the Constitution do not need to expose themselves to actual arrest or prosecution. Where a plaintiff raises a pre-enforcement challenge to a federal statute, the injury in fact requirement is satisfied, where the plaintiff shows a serious, quote, intention to engage in a course of conduct arguably affected with a constitutional interest, but proscribed by a statute, and there exists a credible threat of prosecution thereunder. So the plaintiff's intent must be serious, and the threat of prosecution must be credible. This is not this court's first tasting of pre-enforcement challenges. See Paxton v. Restaino. In Paxton, this court considered a similar pre-enforcement challenge to federal statutes, requiring individuals who wish to make a firearm silencer at home to first apply for the government's permission and pay a tax. The Fifth Circuit affirmed this court's dismissal for lack of standing because the individual plaintiffs neither alleged an intent to violate the law nor alleged enough specifics to demonstrate the seriousness of their intent. As a result, they could not have faced a credible threat of prosecution. But here, the opposite is true. First, individual plaintiffs have shown a serious intent to engage in proscribed conduct they believe is affected with a constitutional interest. The statute at issue make it a crime to possess a still with intent to produce distilled beverage on residential property, among other locations. and all individual plaintiffs allege an intent to distill beverage alcohol, but for the federal prohibition. At least one plaintiff currently operates a still in a shed on his residential property. Oh, you legend. Permitted for distilling ethanol. Another currently possesses a still in his garage that he has used to produce ethanol in the past. Another possesses a permit to redistill alcohol at his place of business and could easily transport one of his business stills to his residence. And the fourth has become proficient at making beer and wine at home and has identified one missing part, a condenser, to repurchase before his home still is operable again. In short, each of these plaintiffs is no more than one overt act away from criminal liability under the challenged statutes. Likewise, all individual plaintiffs possess the requisite expertise to distill beverage alcohol if they wanted to. Plaintiff Cowdery has already, quote, crafted a recipe for apple pie vodka. Oh, wow. That sounds... Oh. I'll be in line for that one. And lists its constituent ingredients. Plaintiff Price is already proficient at home brewing beer and wine and knows how to equip his still to produce liquor. Plaintiff Morris is no joke either. He is a certified bourbon steward, which entails mastering the art of tasting spirits and learning the science behind distilling and aging. He also operates Brewhouse America Inc., a company currently allowed to redistill alcohol. And Plaintiff McNutt has an electrical engineering degree from the United States Coast Guard Academy. Currently distills alcohol for fuel and understand that the chemistry of distilled alcohol is nearly identical regardless of its use. In sum, these plaintiffs know what they want, what they need to do it, and how to make it happen. Thus, plaintiffs show a very serious intent to engage in proscribed conduct. Second, the threat of prosecution for such conduct is credible. Plaintiff McNutt received an unsolicited letter from defendant TTB entitled Notice of Potential Civil and Criminal Liability, signed by the director of the TTB's Trade Investigation Division. The letter states that it has come to the Alcohol Tax and Trade Bureau's attention that you may have purchased a still capable of producing alcohol and or equipment and the materials that may be used in the manufacturing of a still. Troubling, right? The letter further admonishes its recipient that the unlawful production of distilled spirits is a criminal offense punishable by fine up to 500,000 and or imprisonment for not more than 5 years. The letter finally reminds recipient that anyone wishing to produce alcohol for whatever purpose must first obtain the necessary federal permits, even though TTB notes that no permit will be considered for the home distillation of beverage alcohol in any case. Though this letter does not make it as certain that plaintiffs will be prosecuted, it certainly makes it credible. The government received plaintiff's information from somewhere. It was able to identify and notify those citizens who purchased the equipment for stills. Accordingly, these notices of potential criminal liability are one step short of a target letter, ordinarily issued in criminal investigations. Thus, they make the threat of prosecution sufficiently credible for Article 3 standing. But because the court has advanced this matter to summary judgment, plaintiffs must each produce sufficient evidence to establish standing. The receipt of TTB's notice is critical for determining the credibility of prosecution against these individual plaintiffs. See Paxton. Without it, plaintiff's sincere intent to engage in proscribed conduct is not enough. The sincere intent must be accompanied by a credible threat of prosecution. And without the liability notice, a plaintiff may hypothetically intend to break the law with no threat of retribution. Here, only Plaintiff McNutt received such a notice. Therefore, on the present record, only individual Plaintiff McNutt has established a sincere intent to engage in proscribed conduct while facing a credible threat of prosecution. Accordingly, the remaining individual plaintiffs will be dismissed. So, only Mr. McNutt, that's a legendary name, will the case be about. Yet the government argues that the proscribed behavior is still not, quote, affected by constitutional interest. The government claims that while plaintiffs in this case claim that Congress lacked the constitutional authority to enact the statutory provisions at issue, they do not assert or claim that the statute violates any constitutional protected right. This rebuttal is unavailing. The question of whether the Constitution or any court has recognized a particular right under the Constitution should not be conflated with the public's interest in ensuring that Congress has not acted beyond its enumerated powers. Indeed, the restrictions on government power in many Americans' mind are likely to be affirmative prohibitions, such as contained in the Bill of Rights. These affirmative prohibitions come into play only where the government possesses authority to act in the first place. If no enumerated power authorizes Congress to act, that law may not be enacted, even if it would not violate any of the express prohibition in the Bill of Rights or elsewhere in the Constitution. Thus, the plaintiff need not allege the violation of an articulated right to keep Congress in his lane. Plaintiff McNutt has done just that. He has demonstrated a legal interest that could be lost if he is prosecuted for engaging in conduct that he believes Congress has no power to prohibit. McNutt has therefore suffered an injury in fact sufficient for Article 3 standing. The government next contends redressability and causation. In sum, the government contends that the distilling activities they wish to undertake would still be subject to various state and local restrictions and requirements. But plaintiffs contend that they cannot have a state or local permit until a federal permit is issued. Thus, plaintiffs have established causation and redressability because the federal ban on home distilling is the necessary prerequisite for complying with any other law, regardless of whether they are the subject of that suit. Similar to standing for a pre-denial of benefits challenge, McNutt has standing to challenge the federal prohibition here because it is the first hurdle to any permit he could receive from state or local authorities. These cases stand for the following proposition. When the government erects a barrier that makes it more difficult for members of one group to obtain a benefit, the injury is the denial of equal treatment as a result of the barrier, not the ultimate inability to obtain the benefit. To be sure, this is not an equal protection case, but the basic principles are illustrative of why the government's theory of causation fails, where a plaintiff's remedy hangs in part on compliance with state law, but that compliance is prevented by federal statute. The federal government does not get rebuff causation by claiming, "It's not me, it's the states." If no one had standing to challenge the federal government's overreach of authority merely because there could be a state law they had to pursue next, then the federal government could knock the wind off any state's authority on any subject within the jurisdiction it shares with the feds. Federalism would indeed give way to pure subjugation. Accordingly, plaintiff Scott McNutt has established Article 3 standing to challenge the prohibition at issue. The court now turns to whether the Hobby Distillers Association has standing. And I'm going to skim through. For the reasons above, the court concludes that only individual plaintiff McNutt and association plaintiff Hobby Distillers Association have standing to pursue this action. Individual plaintiffs Rick Morris, Thomas Cowdery, and John Price are therefore dismissed. No. The court now turns to the merits of plaintiff's claim. The taxing power, the enumerated power to lay and collect taxes. I do labor law. Even for me, this is boring. So let's skip through that. The necessary and proper clause. Let's skip. I could edit all of this out, but I'm not a fan of editing. This is more or less how I would do in a live stream. Just saying. And if I did this as a live stream, this would be a 3-hour live stream, and I simply don't have the time. I'm so sorry, folks. You can also treat this as a live stream by giving the money thanks in this comment section. No, don't. I might watch it, give it thumbs up, and comment, and I get a few bucks in ad revenue. That's plenty enough for me. The commerce power. Oh God, that's also boring. Let's get back to down to the actual decision here. Conclusion. There it is. The judiciary has long been hesitant to abrogate the actions of Congress absent the clearest abuse of its powers. This presumption that Congress will pass no act not within its power should prevail unless the lack of constitutional authority is clearly demonstrated. Indeed, the invalidation of an act by the people's representatives ought to be one of the most reluctant decisions of a federal judge. Holding that, when given a choice between reading a statute as violative of the Constitution or not, the judiciary's plain duty is to adopt the reading that saves the act. Every reasonable construction must be resorted to in order to save a statute from unconstitutionality. But the court's deference in matters of policy cannot, however, become abdication in matters of law. Indeed, the Constitution is written to prevent societal amnesia of the defined limits it places on this government of and by the people. See Marbury 1 Cranshaw 176. That is where the judiciary must declare when its co-equal branches overstep their constitutional authority. Congress has done so here. Accordingly, having advanced plaintiff's motion to the merits, the court grants plaintiff's request for relief, declares that 26 U.S.C. 5601 and 26 U.S.C. 5178 are unconstitutional. The United States government is hereby permanently enjoined from enforcing these on any regulation promulgated thereunder against individual Scott McNutt, a social plaintiff, Hobby Distillers Association, or the association's members. But the court dismisses individual standings Thomas Crowley, John Price, and Rick Morris for lack of standing. However, the court hereby states the applicability of this opinion in order for 14 days from the date of this order to allow the federal government to seek emergency relief at the appellate level, should they choose to do so. So ordered on this 10th day of July 2024, Mark T. Pittman, United States District Judge. So, to make a long story short, can you start brewing? No. This decision must be first, we'll see if the government appeals it, which they probably will, and then we have to wait and see to what an appellate court does. And then it's up to the states. What will be the states' regulations in this, and will that be constitutional? So I will be very, very careful with bringing out the glass tubes, the big boiler, and the cooling system just yet. I would be careful. This is not legal advice. I do not give legal advice on this channel. So there it is. I hope you got a better understanding on this one. And, well, that's what I have for you today. If you want to know more about this more weird part of the law, then write so in the comment section. Remember to hit the thumbs up and subscribe if you have not. That is what I have for you today. Thank you for listening, folks. Have a good one. Bye-bye.